Current Affairs show on television. The point of view will pick the most relevant topics, get the right guests, and ask them the important questions on issues that matter. Tonight, we're going to look at the matter involving James Gyakye, where Michael Nkuman, in fact, resident of Yamaransa in the Central Region, managed to secure a Supreme Court ruling or judgment, essentially declaring that Mr. Gyakye's election as MP for Assin North is null and void, and also to get the Parliament to expunge his name from the records. We'll tell you how we got here. I have two legal minds to break down what this particular Supreme Court judgment means, so we all understand. We'll be right back.
Many people think I get whatever I want because I'm a popular actress. But no, that is not true. Me Alcasano, Adebia mi yebiano, me shishimpe papano. And when I find it, I stick to it. My shishimenya Bell Pack tissues. Bell Pack ewe tea roll. Bell Pack tea roll. Soft, but not weak. Strong, but not hard. It is smooth. Me yusua, me hot tummy. It's just perfect. Same as the kitchen towel. What's about what? What's me the papaye? What's me soki? Echimu esa pepa. One Bell Pack kitchen towel lasts longer and saves you money. It's time you switch to Bell Pack today. Say your pocket tissue, table napkin, tea roll, and a kitchen towel. Bell Pack is simply the best. It's just perfect.
Nothing feels so good like Bell Pack.
Welcome back. So tonight we will try and break down the Gyakye matter. On the 27th of June, there's going to be a by-election in that constituency. How did we get here? We'll try and break down just the Supreme Court judgment, because that's brought finality to the matter. The defendant has decided not to appeal, although there was a court of appeal case that was pending. In studio, I have lawyer Clement Kojo-Akapam to help us appreciate the matter. Good evening, Clement.
Good evening, Bernard.
It's good to have you. I also have lawyer Richard Delaskai, also on the program. It's good to have you, Richard.
Thank you so much, Bernard, for the opportunity.
Wonderful. I just wanted to give viewers a quick overview of how we got here. In November 2020, a group calling itself Concerned Citizens of Assin North petitioned the Electoral Commission in Central Region to withdraw the candidature of Mr. Kwesi, arguing that he still owed allegiance to Canada. Now, Mr. Gyakye had stood on the ticket of the NDC in the parliamentary election in Assin North, got 17,498 votes, which was 55.21%, while Abuna Druwa Mensa of MPP had 14,193 votes, 44.79%. Now, following the failure of the EC to withdraw the candidature, the election was held, he won the election. Michael Nkuman, in fact, a teacher and resident of Yamaransa in the Central Region, subsequently filed a petition at the Cape Coast High Court after the election, seeking to overturn or annul the declaration of Mr. Kwesi as MP for Assin North. Now, the Cape Coast High Court upheld Mr. Nkuman in first request and declared the parliamentary election held in Assin North as null and void. Now, Mr. Gyakye then proceeded to the Court of Appeal to essentially get the High Court decision overturned. And while that matter was still in motion, Mr. Nkuman, in fact, then proceeded to the Supreme Court. And his Supreme Court case then compelled Mr. Gyakye to also respond to the matter. And he brought the matter to the Supreme Court after Mr. Gyakye had filed the matter at the Court of Appeal. Of course, he was challenging the eligibility of Mr. Kwesi as the MP for Assin North, following allegations that at the time that Mr. Gyakye's nomination was filed, which is in and around October 2020, he held dual citizenship in Ghana, so he was a citizen of both Ghana and Canada. Now, the Court of Appeal dismissed Mr. Gyakye's case, and then he then went to the Supreme Court to have his issues resolved. And so there were different cases running here. What we'll do tonight is sort of just walk you through quickly this final Supreme Court case what were the issues at stake, what were they trying to determine, and then what was the outcome, and whether my lawyers here agree with all the Supreme Court has said or not. So, gentlemen, so far I've tried. It's a long thing. They appealed to the Electoral Commission. EC went ahead to hold the election. The man won, sworn in. Even that there was an attempt to prevent the swearing in, but it happened. The Ankuman in fact goes to the High Court, secures a ruling. Jachi Kwesi goes to the Court of Appeal. Ankuman in fact goes to Supreme Court. Jachi Kwesi goes to Supreme Court. So there's a lot of things going on there. One confused people that what I wanted you to do for me was to say, in this final judgment that we have, the person who went to the Supreme Court, in this case, the plaintiff, is Mr. Ankuman Infa. What was he asking the Supreme Court to do? In this final one that we have all determined. Do you get my point? Sure. What was Mr. Ankuman Infa's main prayer to the Supreme Court?
So, in short, he was seeking an enforcement of the provisions of the Constitution. If you look at Article 1 of the Constitution, 1(2) of the Constitution, it tells us that the Supreme Court, the Constitution of the Republic is supreme, and that if there is any action or anything, a law passed that is inconsistent with it, that will be struck down, considered unconstitutional. And under Article 2, the Constitution empowers a citizen of Ghana, either natural or natural, to go to the Supreme Court seeking to enforce the Constitution, and may also require the Supreme Court to interpret provisions of the Constitution. Of course, if you look at Tufo versus the Attorney General, by reason of his citizenship of Canada, as of the time that he was submitting his nomination papers, that was in breach of Article 94(2)(a) of the Constitution. Because if you go to the provisions of the Constitution under Article 94(2)(a), the relevant provision says that 94.
I can read it.
Yeah, okay. It says that a person shall not be qualified to be a member of Parliament if he, the relevant one, A says, owes allegiance to a country other than Ghana. You understand?
So that's the key point.
Exactly. So he went to the Supreme Court seeking what ordinarily would be a definition or an interpretation of allegiance to a country other than Ghana. So that if properly enforced, then there will be an enforcement of the Constitution and its removal there from Parliament.
And he was relying on a number of things. The fact that at the time that Mr. Jachi Kwesi had filed the nomination, he had not renounced fully and properly his Canadian citizenship, so that in that October period that he filed, he was a dual citizen.
Yeah, so that if you look at the position of the High Court, and then also the findings of fact as made subsequently also by the Supreme Court, Mr. Jachi Kwesi had actually started the process of renunciation.
Yes.
And according to him, COVID impacted the process, so that it wasn't until sometime in November 2020 that he received from the High Commission here in Accra certificate of renunciation of his citizenship.
So that before the election in December, he had received the certificate.
Yes.
But as of the time he filed the nomination
exactly
in the EC,
October, yes, in October, he had not received certificate of renunciation.
Good.
So although the EC accepted his nomination of his renunciation of Canadian citizenship.
we will not go to the full judgment yet, but in the beginning of the case in the Supreme Court, the justices made reference to the Zaneto Ajiman Rawlings case, in which the then MP, Ni Amashite, had brought an action against her. My understanding is that at the time Ms. Zaneto won the NDC primaries, she was not a registered voter in Klotekole. So when the matter was sent to a court, the Zaneto then proceeded to the Supreme Court to basically say that at the time that I had done the NDC primaries, I have not yet filed my nomination in the Supreme Court, in the EC. So you are essentially pre-election. So if I have filed my nomination at that, the material time for the
elections with the Zaneto, you know, these matters were being litigated at the High Court, and then there was a further, you know, escalation of it, because
the Zaneto
thought that, you know, we needed a certiorari to quash what was happening in the High Court, because she essentially disagreed with what was happening there. So at the Supreme Court assumed jurisdiction over the matter because it felt that there were constitutional matters which only they can deal with under the Constitution. If you read the combined, effects of Article 2
and that constitutional matter was what?
Which was the time at which you can be considered a candidate and filing therefore.
So they settled the matter that insofar as Zaneto had not yet filed at the EC, she cannot be considered a candidate. So she couldn't have been in violation of any law.
Exactly, because it is only at that point that we can properly say that you are coming to contest an election.
Wonderful.
Because the NDC could have changed his mind at any time.
So then, Nkrumah in fact then cites this in his sort of statement of claim that the time that Mr. Jachikwesin filed, he had not renounced his Canadian citizenship. And therefore, based on Article 94(2)A, he owes allegiance to another country.
Exactly.
And therefore, his eligibility for the election is wrong.
Yes.
And therefore, the election should be declared null and void.
Yes.
This was his claim.
Yes. Right.
Wonderful. Do we know what Jachikwesin's defense has been in this particular Supreme Court case? Because there have been different cases. Do we know what his main defense was?
So it looks like I'm defense counsel.
No. I'm trying to understand the issues before we get into that.
In Jachikwesin's defense, what he will say to those suits is actually two main things. The first thing he will argue is that this is a matter that has to be dismissed preliminarily because it is an election petition that has been dressed up,
disguised as
a constitutional interpretation issue. That's the first major thing he will say. The second thing he will argue at the Supreme Court will be that he had at the time taken steps to renounce and had obtained a certificate subsequent before the election. So his argument is that at the time of polls, December 7th, a certificate of renunciation had been presented to the electoral management body, and the electoral management body was satisfied. So then the electoral management body will go ahead to do what we call publication of polls.
Wonderful.
And say that he is qualified to contest. So that's his argument. So those were the two main things he comes to the Supreme Court.
So the first one he goes with was that this is an election petition disguised as So which means that in the Supreme Court's judgment they have to deal with that issue. Is this an election petition, or do we have? Is this an interpretation matter?
Yes,
because Supreme Court is for interpretation of constitutional matters.
Right. Wonderful. So whether you are invoking the original jurisdiction, whether you have properly invoked the original jurisdiction,
and I think the court agreed that they had invoked. So that means that the first objection of Mr. Jachikwesin is dismissed.
Right.
So now they get to the substantive matter. So far, you're on the same page.
Yeah, that's right.
Good. So now
there's a reason why, though. If you look at the language of the Constitution, says that when it comes to dealing with election petitions at the parliamentary level, you have to start it at the High Court and terminate at the Court of Appeal.
There's a time within which you must initiate your election petition. So what people will ordinarily do is that when they have missed that time frame within which to bring your petition, then they try to find innovative ways of using.
So it was important for the Supreme Court to say that this is actually not an election petition disguised as there's actually a substantive matter to be interpreted. Okay, I think that's so far. Okay, so this matter, what was the Supreme Court's conclusion?
So a number of things needed to be decided. So first of all, you needed to understand whether or not, what do you call it, owing allegiance to a country other than Ghana meant holding on to the citizenship of that other country, which is the alternate country. So in coming to a decision on that matter, they relied on an earlier decision that was made in the case of Asari versus the Attorney General, which is the citizenship case, dual citizenship case. You remember
2012?
Yeah, that's right. The Professor Kweku Asari went to court regarding matters he thought were unconstitutional demands for certain cards to be produced for Ghanaians outside who wanted dual citizenship and all of that. The Supreme Court, in deciding the matter, dealt with the issue of allegiance, dealt with the issue of what the framers of the Constitution were minded to achieve by saying initially, if you look at Article 8 of the Constitution previously, there was no provision for dual citizenship. It was when we, the people of Ghana, subsequently through Parliament, amended the Constitution, that was when we inserted into the Constitution a provision that says that a Ghanaian citizen who is so minded can take on the citizenship of another country. But what that has done is all the implications we see today, where members of parliament, what they call it, people outside the country are saying that, look, we also contribute to
pay tax sometimes.
Exactly.
So we should be allowed to enjoy the rights of full citizens.
Exactly. So when the Supreme Court was called upon to deal with the matter of citizenship versus allegiance, they took a view that they thought was inconsistent, which was consistent with the thinking of the framers. And in doing that, Bernard, they went to the report of the constitutional, what's the name?
The Committee of Experts.
The Committee of Experts.
The people who wrote our constitution, there are reports that provide additional information on the thinking behind these things.
Yeah.
So Justice Atuguba went to that report to now make a determination that Cyrus Attorney General case.
There's a reason.
Which is what this court is now using. I just wanted to get that as preliminary clearance.
Okay. There's something known as aids to interpretation.
Yes.
When you are interpreting a constitution. The rule is that you don't interpret the provision different from what the original maker intended.
Wonderful.
So if you want, if for instance the word is allegiance, and you can't find a definition of allegiance,
you go to the
so you go to the aids to interpretation. One of them is either at the Hansard of Parliament or this report.
Okay.
So the report gave an idea of what the framers were thinking.
Okay.
So Justice Atuguba relied on that
in the 2012 case.
Exactly.
And then, so what was his conclusion in that case?
So generally, he took the view that the framers were minded to achieve a certain effect, and they saw a connection between what is known as allegiance and citizenship, and that the two of them have an interconnection. You cannot, look at one without looking at the other.
Allegiance and citizenship are interwoven.
Yeah, they are interwoven. There's a connection between them.
But they are not the same.
They are not the same.
Let me make a comment.
No, so, I mean, it's a very interesting point Richard Sky tries to make by going back to Asari AG number 2 and bring the point out on what Atuguba said in relation to dual citizens. Now, what we need to get clear is that our Supreme Court is not bound by its previous decisions. So if you are talking about aids to interpretation, they are not bound by their previous decisions. Our Supreme Court is such that once every matter comes before it, the Constitution has given it the power to look at it within a certain context. So that's the first thing. Now, if you look at Asari AG, clearly it was an issue on dual citizenship. The quotation of Atuguba in Asari and Attorney General on allegiance was to explain that when it comes to dual citizens, the reason why we are not allowing them to occupy certain positions,
like president, vice president,
is
chief
because
justice,
their allegiance is to other countries. Now, that decision, people have questioned the basis over time. The point I want to make, particularly when it comes to allegiance and saying that whether it is synonymous, whether it is intertwined, whether it is the same thing, is I hold the view that allegiance, when it comes to citizenship and allegiance, the allegiance of every citizen is presumed. So as we sit here, we are all Ghanaian citizens.
Yeah.
We don't know whether we've acquired any new ones yet.
I have not.
But we are all Ghanaian citizens. There's a presumption that we will hold allegiance to Ghana, meaning we'll be loyal, adherents, respect certain values. Now, there's a spectrum of allegiance. There is allegiance that even non-citizens, persons who are ordinarily resident, will hold to the state of Ghana. The point I'm making is that if we say that we link allegiance to citizenship, there's a certain difficulty, and that difficulty is that everyone who is a citizen is presumed to own allegiance. However, when it comes to our members of parliament, and then when you look at the qualification provisions here, the distinction is clear. In Article 94 1A, it says he is a citizen of Ghana.
Yes.
That's what it says.
So let me read it. 94, subject to the provisions of this article,
Yes.
a person shall not be qualified to be member of parliament unless A, he is a citizen of Ghana, has attained the age of 21, and is a registered voter.
So what does it mean to be a citizen of Ghana? Then when you go to 94(2)(a), it says
a person shall not be qualified to be member of parliament if A, he owes allegiance to a country other than Ghana.
Good. So then it means that you can be a citizen of Ghana and owe allegiance to another country. Or you can be a citizen of Ghana and not owe allegiance to any country.
You think that's why they separated the two?
That's why they separated the two.
Okay.
Allegiance, as I understand it here, everyone is allowed or is mandated under the law to owe allegiance to the states where you are recognized as a citizen. A non-citizen, when we are playing the national anthem today, all non-citizens will get up in a public function. It is a form of allegiance, but it's not the level of allegiance we are looking for.
So you're saying it's a spectrum.
It's a spectrum. And that is why at the level of being a member of parliament, even when we have satisfied ourselves
that you are a citizen,
that you are a citizen, you will take and subscribe to an oath of allegiance.
So you're saying that there are higher allegiances in levels?
There's levels. So when it comes to linking allegiance to citizenship, I will agree to the level that every citizen, we have a certain level of allegiance that I will call patriotism, loyalty. But there's something else that we need to avert our minds to, which is occupational allegiance.
So let's pause there. Sky, what did the Supreme Court say in this case about allegiance? Because you seem to suggest that they relied on the Asari Attorney General Atuguba, where Atuguba gave us a sense of how he sees allegiance. And for him, he made allegiance coterminous to citizenship. And the court relies on that to say that if you don't have citizenship, so if you have citizenship from another country, it means you are allegiant to that country. So it's almost like very similar concepts.
Yeah, I would in answering your question, let me just quote from the judgment.
Yes.
Two key
what page are you on?
Definitions of allegiance, which is page 29.
Page 29.
Yeah, of the judgment. If you go to the judgment, the PDF version, they say that they quote G.W. Keaton, the elementary principles of jurisprudence, at page 39, which is the second edition, published in 1949. It defines allegiance as, quoted unquote, allegiance implies submission to all properly authorized commands of the state and acceptance of the tribunals of the state as a vehicle for determining and enforcing those commands. Protection and allegiance are
indissolubly divided.
Divided. That's a heavy word.
So if you
cannot dissolve it, yeah, right? Yeah, they're bound together. Now, if you go to the other one, which is Black's Law Dictionary, yeah,
a citizen's or subject's obligation of fidelity and obedience to the government or sovereign in return for the benefits of the protection of the state.
Okay. So Bernard, quick one. This is the Black's Law Dictionary, and they don't just throw words around. It says a citizen's or subjects.
So your point is that both a citizen and a subject can
owe allegiance,
which is why they separate the two.
Yes,
based on Black's law.
And this is evident if you look at other jurisdictions and their laws, even in the case that will be quoted in
so you are saying from the Black's law definition, but a subject is not used. Hold on, a subject is not being used as distinct from citizen. It's being used in a type of government.
Exactly, that's right. The monarchy.
Exactly. Yes.
So the British citizen is a subject of.
So it's not being distinguished as in a citizen or non-citizen. Because a subject in a monarchy is a citizen.
Yes. But the point I'm making here is that there are persons who will owe allegiance who are not citizens. So
that's if they're in a kingdom. Yes, if they're in a kingdom.
Exactly.
But if they're in a republic, they have to be citizens.
No, Bernard, that's so.
Because if you are said a citizen or subject or resident or domicile, you understand? Because a citizen means that you are in a republic.
Yeah.
Subject means you are in a kingdom.
Look at page 6.
Page 6 of the judgment.
Yeah. Okay, let's go to page
when they
6.
quoted the Australian guy.
In that case, you'll be relying then on the case of the plaintiff.
Yes,
it's fine. But I'm just using it to point to what I'm saying about the distinction.
Sky substantive 10, but you go ahead.
No. It says any person.
So sorry, section 44 of the Australian Constitution. That's what they are quoting. The Gallagher case.
Yes.
Gallagher.
Go on. It says any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or citizen.
Okay.
So you see that in there.
They distinguish between citizenship and then forms of allegiance, obedience, and adherence is a spectrum.
So the argument I'm making is that as citizens, ordinarily, you are all bound to hold allegiance to your country. We agree. And that species of allegiance is patriotism.
And don't forget that 94 is saying that you don't qualify to be an MP if you have allegiance to another country.
Yes.
Hold on.
So what type of allegiance are we talking about here?
Yes. So by holding the citizenship of Canada, you owe a certain degree of allegiance to them.
Okay.
That's my understanding.
So a citizen of Ghana,
yes,
who moves to the United States,
yes,
still as a citizen of Ghana,
yeah,
working in the United States,
yeah.
Now that citizen decides that he's paying his taxes there.
Yeah.
There's a football match between Ghana and the US.
Yeah.
He supports the US, wears the US flag, sings the US national anthem. Does he owe allegiance to the US?
If he has a US passport, if he has a US passport,
no, he doesn't.
So he doesn't.
He doesn't. So the point I'm making is that there are things you will do that will be support, obedience, adherence.
But is this case not trying to find allegiance as law? What does the law say about allegiance? Not in common English usage. So you're basically trying to say that if we are trying to find allegiance in interpreting what the Constitution says about your eligibility,
yes,
what does our Constitution define as allegiance? Yes. That's what they're trying to find.
So if I agree with you,
so it can't be.
If I agree with you
yes,
that allegiance is citizenship,
yes,
then the point I'm making is that it's superfluous that a person who has proven that he's a citizen of Ghana and is elected a member of parliament or is ascending to another office of state is made to take and subscribe to an oath of allegiance. That's the point I'm making.
So you're saying that once they make you take that oath, even though
that is where you
it means that allegiance is more serious than citizenship.
Exactly.
That is why let's get the point. You're saying that a Sky is a citizen.
Yes.
He's won an election.
Yes.
Yet before he becomes MP, he swears an oath of allegiance.
And for the 4 years that he's in parliament, that oath is valid.
But the question you need to think about before we take the break is allegiance the same as an oath of allegiance?
No, it is, because allegiance.
No rush. Let's relax.
No.
If you see, because the oath of allegiance versus allegiance. The 94 is saying
one has legal implications.
Yes, you see. So one is like a declaration of allegiance in an oath.
Overt act. Because that's what I'm saying.
We
presume that all of us owe allegiance.
Yes.
But the one that you will publicly declare, that's the overt act. Because as we sit here, nobody will
we'll take a break. We'll come back and pick out where the lawyers agree and disagree. We'll be right back. Stay with us.
Pepsodent introduces charcoal and lemon essence. A unique combination of natural essences whitens teeth naturally for you and family because every smile matters.
New Pepsodent Herbal. Introducing a unique combination of herbal extracts in an antibacterial toothpaste for strong teeth and healthy gums that protects your family and you. Every smile matters.
Welcome back. So the point of view tonight is trying to break down the judgment in the matter of Amkuma Nimfa versus Attorney General Jachi Kwesen and EC, in which it was determined that the election of Jachi Kwesen as MP for Assin North is null and void, because at the time that he filed his nomination at the EC, he was a dual citizen, or he has citizenship of Canada in addition to that of Ghana. Therefore, by Article 94 2B, A and B, 2A, he is ineligible. Brilliant. Sky, just give some meat to the Supreme Court's judgment. Give me the relevant pages. What was the main reason why the Supreme Court upheld the plaintiff's case?
Yeah, I think it will be useful to actually quote from the committee report that I referenced earlier.
Okay.
So that it will help the
as quoted by this court.
Yeah, that's right, by this court and also by Justice Atuguba in the Asari versus.
So what page are you on?
So I am on page 27
of the judgment.
Of the judgment.
Wonderful.
Which is paragraph 374 of the decision in Asari versus the Attorney General, as quoted by Justice Atuguba, the report, the committee's report. Now, with your permission, it says that what the committee considered the recommendations in the NCD. Okay, so D. Okay, report that the question of prohibition of dual citizenship for Ghanaians, as provided for in the 1979 Constitution, should be examined by it. Now, our law provides, amongst others, that if a Ghanaian of full age voluntarily swears allegiance to another country and becomes a citizen of that country, then he loses his Ghanaian citizenship. The issue before the committee was whether there was any justification for altering this law so as to enable Ghanaians acquiring the nationalities of other countries to retain their status as Ghanaian citizens. On this opinion was divided, 375. One view was that the committee could not dismiss the question of allegiance, which is indeed at the root of citizenship, and this is highlighted in bold. Let me repeat. One view was that the committee could not dismiss the question of allegiance, which is indeed at the root of citizenship. A country owes specific duties to its citizens. For example, it is its responsibility to evacuate them in times of war or crisis from any foreign land. There is reciprocal responsibility of the citizen not to engage in acts which would put the security of the country at risk, to mention just one. The question of allegiance should therefore not be taken lightly. As the Akufo-Addo report stated, quote, "We do not want an occasion where allegiance to Ghana is shared with allegiance to some other country," unquote, emphasis ours. The opposite view was that such a dual citizenship could be justified. He went on to say on page 485 and page 487 respectively of the report, quote, "To begin with, it seems to me that citizenship is a matter of state sovereignty and has a unique and intricate character which has been specially dealt with in chapter 3 of the 92 Constitution." Quote, "In particular, the dual Ghanaian citizen is a unique creature of the Constitution as amended. He was hitherto proscribed by the Constitution, save in very limited situations, because he would pose as much greater threat to national security, since he was torn in loyalty between two or more countries, and therefore the question of equality of rights in relation to him simply did not arise. What his rights should be upon being let into dual citizenship of Ghana can only depend on what has been conferred on him by the Constitution, with due regard for national security as evidenced by the limitations on the holding of certain offices." On page 489, he said, quote, "Parliament, as aforesaid, amended the 92 Constitution to admit dual citizens without disregard for the element of risk to stable allegiance to Ghana. Hence, even though Article 94(2) is not an entrenched provision, it nevertheless did not delete it but expressly retained it." On page 492, Atuguba went on to say, "It is noticeable from the offices which cannot be held by a dual citizen of Ghana that they are all high-profile or leadership positions, Articles 2865, which involve confidentiality and unalloyed allegiance to Ghana. And if some other countries do not consider them to be such, Ghana is not precluded from doing so. Dual loyalty has been denounced in the book of the universe, the Bible." Okay, so you see, if he went into the records in an attempt to establish, by reading the committee's report, to understand what could have been the thinking of the framers of the Constitution, as to say that what we want Ghanaians to be Ghanaians only, no dual citizenship, anything. But we, the people of Ghana, after working with the 1992 Constitution for some time, subsequently decided that we were amending it to extend citizenship rights to Ghanaians who had taken on additional citizenship. But you see, in doing so, the framers and the people who were now framing the new regime that we have under this dispensation still retained the idea that there are certain offices in this country which you cannot hold if you hold citizenship or owe allegiance to another country. One is what? If you want to be Chief Justice, if you want to be President of the Republic, Member of Parliament, and all of that. So when the Supreme Court was called upon to give effect and meaning to allegiance within the meaning of Article 94, 2A of the Constitution, they went back to the records and to try and do a connection between citizenship and allegiance. Let me tell you what I believe would have influenced the decision. Look, there are policy reasons why laws are made. and laws are made to give effect to specific things that the people of Ghana want to achieve. The people of Ghana previously did not want dual citizenship, but we brought it upon them anyway. But in making a change to the law, we did not allow for those offices proscribed to be taken away entirely. One of them is member of parliament. So my thinking is that the reason why the Supreme Court went the way they did was to ensure that we have an objective way of determining whether a person owes allegiance to another country or not. Because Bernard, you sitting here, you can't in your mind say that you owe allegiance or you are subject of the King of England.
No.
You can't in your mind. I'm saying
I can in my mind.
Say it in your mind.
But I won't do it. I know. I foresee of argument.
That's right. Me sitting here, if I'm the Electoral Commission, I wouldn't know that.
Okay.
It is only when you confess it. Even if you confess it, there is no objective way of assessing and determining whether or not you owe that allegiance. It is only through maybe specific actions that I would infer that, oh, Bernard, you have been stealing government information.
Owning a British passport.
Exactly. Or maybe you've been stealing government secret information and sending it to the Brits.
Okay.
You understand? So what the Supreme Court sought to achieve was to establish an objective way so that we all know that the moment you take up the citizenship of another country, you by that action have become a subject.
So they use that, and I think it's an interesting point, but Clemens, is that also, you know, in the use, what I read, they describe a certain allegiance, they call it unalloyed.
Yes.
So what they're saying is that, yes, we agree with you that
there may be levels.
There are levels of allegiance.
Once we agree on that, then we don't have a problem.
Yes, but I think the point that the court makes, which Kai seems to agree with, is that if you are looking for an objective way of saying is somebody have unalloyed allegiance to Ghana, if the person possesses dual citizenship, you can say he does not, because his allegiance is divided.
Yes.
That's what they are trying to say. And they quoted Atuguba to confirm this. What's your problem with that?
See, when it comes to dual citizenship, dual citizenship is not an inferior type of citizenship.
Okay.
Every dual citizen at every point in time is in one location or the other.
Okay.
And every dual citizen at every point in time is evincing his allegiance to either of. It cannot be, you cannot be hot, as the Bible says in the Holy Book, you cannot be hot or cold at every point in time.
No man can serve two masters.
So in here, even in the Committee of Expert report that he says, voluntarily swears allegiance.
By citizenship.
He didn't say by citizenship. He says voluntarily swears allegiance of another country and becomes a citizen.
Yes,
the point is that
before you don't, if you are naturalizing,
you have to swear allegiance.
So in the UK too, you do that. US, you do that.
So the only time a Ghanaian will be required to swear allegiance to another country is when the person is taking up the citizenship of that country. So are we saying that there are Ghanaians who do not owe allegiance to other countries by mere fact that they've not sworn allegiance? There are people who are born of Ghanaian parents. They are in the US. They are US citizens. By operation of law, they are dual citizens. You know that?
Yes.
But they have not taken up Ghanaian passports. So they are considered as sole American citizens. The day they decide to take up Ghanaian passports, they will be considered as dual citizens.
No, they are technically speaking. Wait. Now, if you go back to the Constitution, Article 8, we are told who exactly. I think section. What do you call it?
I'm saying that by operation of law, by your.
Let's agree on that.
That's what I'm saying. By your test, that person will only be holding the US passport.
But he is a Ghanaian citizen.
By operation of law. So are you saying that he's a dual citizen? That person.
So that person. You're saying that if a Ghanaian, like you go and give birth in America, and you are Ghanaian, so because you give birth in America, he has an American passport. But because his father is Ghanaian, he's also Ghanaian, even though he doesn't have a Ghanaian passport yet.
Yes. So you see,
citizenship is not passport.
Yes,
it's a citizen because
a manifestation. It's just a document to prove that you are of this country or you are of that country.
So that's why he's saying that when you flip the argument, the guy is in Ghana, and he's fully Ghanaian based on his Ghanaian birth, and he's been in Canada for some time, has a Canadian passport, which he has begun process to even renounce. Why is it that in that sense, if you're saying that the guy in your son born in America is Ghanaian, even though he doesn't have a Ghanaian passport, why can't you say that this guy being in Ghana is also fully Ghanaian, and the fact that he has a Canadian passport, which he is renouncing, does not necessarily reduce his rights of being a Ghanaian passport.
The court cleverly answered that question.
Okay.
And let me take you to what the court said. In effect, they argued that...
give me the page and I'll read it for you.
Yes, I'm trying to get to that.
This is in the conclusion.
Yeah, in the conclusions.
On the renunciation.
So yes, so let me take you to that. That is on page 33.
33.
Yes, the second paragraph on page 33.
Okay.
In the same way that the obtaining of alternate citizenship is done through due process and by legal means, we are satisfied that without a legal record granted by the state that conferred the alternate citizenship, persons who present themselves as having renounced their alternate citizenship cannot be accepted as having done so unless they show an official record stating so from the alternate state. Good. Now, to accept such a proposition will make a mockery of the weight that Ghana and states place on the grant of citizenship, other than through birth and the rights and obligations that go with holding allegiance to a state. Much earlier, which responds, specifically to this unilateral declaration that I'm no longer, they said much earlier that since citizenship...
What page are you reading?
This is on page 32 now. Since citizenship is a matter of law and is determined by the law and the regulatory mechanisms of states, it is not a valid legal submission that a unilateral statement of renunciation of citizenship of another country should be recognized as severance of allegiance from that country. So
this quotation, I totally agree with it. I totally agree with it. And that's also my position on this judgment. I agree with the conclusion.
Okay.
That you cannot, at the time of
filing your nomination.
No, so filing, I'll come to that. So that time, at the time of deciding to contest as a member of parliament for Ghana, you cannot be holding the citizenship of another country. I agree with that. So the fact that you have commenced a renunciation process is not enough, because you can actually decide to abort the process.
I get you.
So it's not enough. If the country that you are seeking to renounce the citizenship requires a renunciation certificate, that is what you must produce.
Okay.
Now let me come to how the court...
So by the way, in Canada, that's initiating the process...
It's not enough.
Oh, so then the matter is clear?
Yes, in Canada you require... No, in Canada you require a renunciation certificate. How do we know this?
Which you did not possess at the time he filed.
At the time. So I'll come to time.
Yeah.
The point I'm making is that Canadian law, right, is the law that determines how you acquire Canadian citizenship and how you renounce Canadian citizenship. That is not a determination of Ghanaian law.
I get you.
Now, if the Ghanaian courts want to rely on Canadian law by our rules, foreign law is a question of fact. It has to be proven like any other fact in our courts. So our courts could have arrived at the same conclusion, which I agree with, by relying on the processes of proof of foreign law. And invite a Canadian expert.
Interesting.
Instead of, because if you
just taking the law like that. Okay, next time.
Zenator is on registration, so it's not on citizenship. The nuance analysis at arriving at who a citizenship is, it's not the same as have you registered. It's not. They are different.
But are you saying that even though Canadian law is clear about how to renounce citizenship, which by a common reading of the law you can understand, you still
cannot just give
prove it.
No.
So you need to probably call. Let me get his point. So you're saying that you could have invited the registration official in the Canadian birth registry, and say to him, Mr. Kofi Mensah, what is the procedure? What is the procedure for renouncing citizenship?
Then he will tell you that, in Canada, if you immediately you put in the application, it's enough. Or he will tell you that
if you give the certificate before it's enough, then that would have been substantiating the meaning of the law.
That is it.
But so you're saying that they could have used that to then solidify the position.
Because the matter of renunciation is not Ghanaian law.
They say
the matter of acquisition of Canadian citizenship and renunciation is not Ghanaian law. So if the Supreme Court had gone on the proof of law tangent, they would have arrived at the same conclusion and say, I agree with the conclusion. But now when it comes to time...
Could they not have relied on decided cases in Canada instead of inviting somebody? Because you are saying a foreign law must be proved. Can't you use precedent in Canada, some case involving somebody?
Bernard,
so they went to Australia and used some case.
Bernard.
Yeah, no, so that's what
even way after the election, the member had not received a renunciation certificate.
Oh, so as of the time that he had, so that's different.
As of the time he didn't have, after the election he had taken up the seat, he still didn't have.
Okay, but in our case, before the election was held, the guy had already.
So it is.
So the meat. So it means that the meat. Hold on. The meat of this case, there are two issues: the time he filed, relying on that, and are you saying that depending on Zaneto was not the best?
Because this is on citizenship and not registration. Because in Zaneto, if it's registration, and I want to say that it is at the time of filing, which is what the court said. It means that at the time of filing with EC, you should have availed yourself for registration. Policy reason. Maybe the time of nomination of the parties, when the parties will open nomination for primaries, is different from when the EC is opening,
can we not say that,
up for
can we not say
registration.
that even though Zaneto had to do with registration,
yes,
registration and citizenship are both eligibility.
Yes.
So you spread it and say Zaneto case was about eligibility,
yes,
for a parliamentary position.
Yes.
And eligibility has been timed to the, it has been sort of,
so now the court has interpreted it as at the time of,
so whether it is citizenship,
good,
or your mental state, or your age, or your citizenship, it's all about eligibility and the question of the time of filing. So if, for example, I'm 20, I'm 18, I'm 16, 17 years old, right? At a week before filing, and then I file. By the time the election holds, I may be 18 and qualified.
Yes.
But they can still use Zaneto to say that by the time you filed, you were 17.
Good.
And therefore you've lied to the...
So let's apply what you just said to the fact of Judge's question.
Yes.
At the time of filing, he had commenced the process.
But had not finished.
He had not finished. But at the time before the election, the electoral body was convinced that he was qualified. Because when you file, you can file and EC will come back and say, oh, we don't have this document, produce it. We don't have, oh, we didn't see your tax clearance, this page is missing, bring it. So at the time can be back and forth, and for me, at the time is when EC will publish what we call the poll, the communication of polls, and say that in this constituency, these are the people. That's at the time of filing. Filing is not when I take my forms and take it to EC and add the money to it. That there's an administrative process that will go on. Check, oh, you didn't have this. And that is why when the petition was filed, EC will invite him and say, ah, they brought this petition. And said, oh, I've started the process. I will get the certificate for you. When he gets it.
But you see, the reason I sort of take a bit of, if somebody says, oh, I know age is not the same as filing a process.
Yes.
But somebody says, Charlie, I'm 17 years, 360. Time that the substantive filing is finished. So let's assume I'm born May 20th. So maybe 15th May, I go and file. I'm 17 years, 5 days to my 20th birthday, and I file. But the time they give you the go ahead is into 22nd May.
Yes, but you cannot write on your form that you are 18 years.
No, that I will be 18.
No,
but that's what you're saying. That you're saying that you say that. I'm just trying to get that. You say that by the time we do the election, I'll be 18.
No, that's not what I'm saying. I'm saying that in this, you're supposed to show evidence. That you have renounced.
Yeah.
And it's a process.
That so show the evidence. So because
that is why I said that I agree with that. I agree with the conclusion that if you don't have the evidence at the time, you don't qualify. My point is, what is the time?
Okay.
You see? No, it's not the same thing.
Bernard,
listen.
You have robbed me of...
No. This is not. It's not about. I'm trying to educate myself.
Bernard, the thing is,
I'll come back to you.
The agreement is that you need to have had your renunciation certificate at the time. Okay. You have Zaneto saying that it's at the time of filing. You have Ropa law saying that at the time of the election. We're saying that we all agree that the Constitution is supreme. In Zaneto, so it appears Zaneto is supreme. The question I'm asking myself is that if you say at the time, what time are we talking about? Because is it at the time of the election? Because if it's at the time of the election,
at the time of filing, that's the rule in Zaneto. And Zaneto, strictly speaking, is the constitution.
Yes.
Do you know why?
Sky, I agree. No, that's what I'm saying. I agree with you. The reason why we are having this argument is because currently this judgment looks like it's nugatory. Because Justice Assin will, as his party has said, he will contest.
You see,
what certificate? Hold on. What certificate will he present? The November 2020 certificate. So when the court gives judgment, it shouldn't be rendered nugatory. And
how do you know that he will win?
No, it's not about winning. No, it's not about winning. It's whether you qualify to contest.
But he's qualified now, but he wasn't qualified then.
Yeah, it's as simple as that. It's just like saying that previously you were 17 years old, so 300 something. Yeah, you see, at the end of the day,
what made him qualify now is because the certificate at the time.
So the court is saying that at the time you filed, you didn't have the certificate. So we cannot convince ourselves that you were fully allegiant to Ghana.
Yes.
So now we are sure. Yes. So you can contest.
Now, when did he even take the oath?
After the election.
Good.
But by that time he already had it.
He had it. And he had. So if I swear, if I go to Parliament and I take my Bible and I subscribe and
but if you swear, so the citizenship is the foundation, then the oath is the first block.
Yes.
So if the citizenship is not there, so your swearing is rendered useless because you can't do something on nothing.
Yes. If you are in doubt that the person will renounce citizenship, he is gone ahead to provide you a certificate. You say it's not enough. He's gone to Parliament to take and subscribe to the oath and say I will be. What else do you what else do you need?
I'll come back and take Sky's reaction to this. This is the point of view. No, Sky, hold on. I need to pay for the water in front of you. Otherwise, I'll lose my citizenship. So we'll be right back. This is the point of view. Please stay with us.
Can become a household.
Oh, wow.
Yeah. You Go Flip, a real estate gaming platform that allows you to play and stand a chance of winning a house or cash or consolidated funds, such as savings towards a house. Simple and easy to play. Visit www.yougoflip.com. Buy a ticket to enter the game. Wait for the end of the game to enjoy the win. Anyone can win. Flip it or own it. You Go Flip. This advertisement has been vetted and approved by the Gaming Commission of Ghana. Play responsibly, not for persons below 18 years, and gaming can be addictive.
Welcome back to The Point of View. As you can see, I'm trying myself to wrap my mind around the case, and so far my lawyers Clement Akapam and Richie Sky have given me a clear understanding of what was at stake and what the court decided. But I think Sky needs to dot a few I's and cross a few T's. So, look, I've tried to engage him to understand what the court has said. I noticed you were trying to make some interjection when he was making
so first of all, I mean, he stated a position of law which I disagree with.
Okay.
The Supreme Court was not under obligation to invite a foreign expert to come and determine what exactly Canadian law says. If you go to the Evidence Act, Section 4, what that means is that if we cite any law, right? If we so for instance Togo, we are assuming that Ghana's law or Togo's law is the same as the law of Ghana. So if you, the person who is pushing back, says that no, that is not the case, it is now a matter that would have to be tried by the court.
Bernard, this is important. What is Ghana's law on renunciation of Ghanaian citizenship? Does it require certificates?
But that is what
does it require a certificate of renunciation?
You should point me out.
No, that's what I'm saying.
Let's use the Côte d'Ivoire. In Côte d'Ivoire, it doesn't.
So you see, that was why the Afro case is different from the.
But what you just said that a law.
No, I'm trying to push back on something that he said.
No, so that's the point I'm making.
Was under an obligation. If Justice
no, let me explain. What he said was that
I said foreign law.
Yes, you said that the Supreme Court.
No.
No, he said that. He said that the foreign law.
It's a question of fact.
It's a question of fact
that has to be proved. And I'm saying, look, the act.
No, hold on.
I'm
say something has to be proved.
Yes.
Is proof obligation to invite somebody.
You see,
you can prove it in many ways.
You see, listen to the language of the act. The act says the law of a foreign state is presumed. So there is a presumption that the law of Canada is the same as that of Ghana.
Yes.
So that if Jati Kwesen disagrees, then he would have to prove that. But no, we need to bring in an
so you're saying that the evidence, the onus on the invitation was on somebody.
So what I'm trying to dismiss is his claim that the Supreme Court ought to have invited someone to prove.
I didn't say ought. The point I'm making is that we've relied on the Canadian law, right?
We did not.
No, I'm saying that we've made the issue of the point I made, and let me clarify that before we. The point I made is that Canadian law determines how you acquire citizenship and how you renounce it. It is not Ghanaian law that determines how you acquire Canadian citizenship and how. The provision in the evidence decree that he's read, I am aware of it. But when it comes to proof of foreign law, we are saying that proof of foreign law is a question of fact.
Yeah, but it was not on trial.
No, Sky.
It was not. It was on trial in the Ivorian case.
No, Sky. No, hang on. I'm saying that if we want, that's what I'm saying, we could have arrived at the same conclusion without Zenator, because I hold a different view on Zenator. I hold a different view on Asari and AG. By going the route of proof of foreign law to come to the same conclusion.
So what is the point? I didn't say that they were bound. Both of you agree with the conclusion of the Supreme Court.
Yes.
But you think that they could have used a different route to solidify it?
Because the cases of Zenator and Asari number 2 speak to different things.
There are principles of law that we distill from
give closure.
cases.
No, to be able to give closure on this question, it is Canadian law. And
reading the judgment, the judges did not rely on Canadian law.
I didn't say that. I'm not saying that they did. I'm saying that if I was given an opportunity to look at this matter, I won't rely on Zenator, because I say is on registration. I wouldn't rely on Asari.
You only say Zenator is on eligibility.
Yes, because
eligibility and citizenship and registration are all dimensions of eligibility. And so if they use the principle of eligibility and use Zenator, it's clear now.
Scott.
You don't agree.
Bernard, if you look at the two, registration and citizenship is in 94(1)(a).
Yeah.
The question of allegiance is in 94(2).
You see,
A.
Hold on.
It is for. They didn't.
So fine, but he says that. But I just want to point is that the principle that is what they use, not the substance.
The court was not using the facts in Zenator, the full gamut of facts. They distilled a principle, which is a principle which gives effect to the Constitution. That at the time that you are filing to contest, you must qualify. Because if you look at the language of the Constitution, Article 94. We have a qualifying provision and a disqualifying provision. The qualifying provision is the general rule. You must be 18 years, or you must be 21 years and above, you must be a citizen of Ghana, and you must have registered and blah, blah, blah. Then there is a disqualifying provision under Article 94 2A, which says that what? If you are ABCD, a citizen of another country, or you owe allegiance to another country, as has been written in the Constitution, you are not qualified to contest. So under 94A, 94(1), you can qualify.
Yes.
Everybody qualifies.
Yes.
Because you are a citizen. But under 94(2)A, you do not qualify because you hold on to the allegiance of another country. Do you understand what I'm making?
I get you.
The point I'm making. So what I'm saying is that you should not apply Zenator in that case. In that sense, and say that it is the facts that have been applied to the case.
No,
they did not apply the facts. They gave effect to the Constitution by distilling a principle. Which principle says that by the time you are filing,
the only challenge that because eligibility has many criteria, and some
the Constitution states
some of the criteria are objective, factually provable. So, for example, state of mental health. State of mental health. So, for example, as of the time I filed, I was probably in a psychiatric hospital going through mental training, but by the divine grace of God, I've been healed. Okay, so it's not the same. The proof of my mental state may not be as directly provable as the proof of my citizenship.
Okay, so you see,
which is why I'm saying that. So he's saying that that principle is you have to apply it in a very fluid way.
That is why.
So that is why the court itself. The court itself will say that we are applying, and it's in the judgment, we are applying Zenato inferentially.
Yes, I wanted to hear him on that.
By inference.
I want to hear you on. I want to hear him the example I gave.
Bernard.
Yes.
You have made a brilliant point. The Constitution says that you must be compos mentis.
Yes.
Properly constituted.
Yes, please.
If at the time you were filing, you were not properly constituted, and that there was a medical facility in this country that was attending to your needs, which can be taken to court and proved that Bernard, at the time that you were filing,
I was not correct.
You were not correct.
So
it invalidated.
Thank you.
Because at the time you were filing,
so the filing is a very important thing.
Very important.
We'll leave it here.
No, hold on.
We have ended the show.
No, hold on.
Okay.
We are recording, so
no, we are not recording. We have ended the show.
Okay, hold on. Article section 20 of the Representation of the People Act. Yeah. The people have mentioned variously. Yeah. Let me explain what the framers were thinking. If you go to the provision,
that's back.
No, I just wanted. No, it's relevant to this matter you're talking about. Section 20, 1D. Yeah. It says that grounds for cancellation of election results. The election of a candidate shall be declared void on an election petition if the High Court is satisfied. D, that the candidate was at the time of his election a person not qualified, yes, or a person disqualified for election.
Which is the first one.
Yeah, so the first and second. Yeah. So what I'm saying is that the High Court, using this provision, will say that at the time you were filing to contest, because of the language of the Supreme Court in Zaneto's case, you did not qualify. And by reason of the operation of the law, you were disqualified. And therefore, I'm coming under you were not qualified or you were disqualified.
There are two separate things. I thank you.
Bernard, I thank you. All this discussion because the EC did not come and tell us why they thought that Jessication was qualified.
Because
that's a very important
EC was not invited to make...
No, they were a party to the suit. They didn't say anything.
Yeah, they
didn't file anything.
But it is
there's a silence means consent. Look, we'll leave it here. Thank you very much. Let the discussions continue in your living rooms. I've been speaking to Richard Sky, lawyer, and Clement Akapam, lawyer as well. Thank you for watching. We'll see you next time. Bye-bye.
The Point of View is brought to you by Bellpack. Bellpack, just perfect.